Hello, assalamu alaikum viewers. How are you? Today I am discussing about Houston Maritime Attorney General's law, which is of 2022, representing injured seamen in maritime lawsuits nationwide. Billions won. Working as a seaman in the maritime industry is a high-risk occupation. Heavy load, large equipments, seaworthiness, and difficulties conditions can all contribute to an elevated risk of offshore injury. Isolation is another health actor. Where do you go when you suffer a severe injury hundreds of miles offshore? When an injury occurs, expert medical and is often hours away, while life-altering injuries need to be treated immediately. Due to all these factors, a maritime injury can be much more serious than a similar incident occurring on land. If you have experienced an offshore injury, contact our Texas Jones Act attorneys. Now we are discussing about what is the Jones Act. The Jones Act, formerly known as the Merchant Marine Act of 1920, is a specific protection under Admiralty law that provides for any U.S. citizen working as a seaman who suffers injury or illness due to unseaworthiness or negligence abroad, a vessel operating in navigable waters. The statute governs maritime commerce transported between U.S. ports. In addition, the Jones Act offers several key provisions, especially benefiting the maritime employee. The Jones Act was a federal statute enacted to encourage the growth of the American merchant marine. It was also created, in part, to offer relief to injured workers in the maritime industry and to ensure they receive appropriate compensation for their injuries in a maritime lawsuit, also known as Jones Act claim. While Jones Act claim is filed for on-the-job injuries or Jones Act settlement is often far larger than a workers' compensation claim. One reason for that is, unlike a workers' compensation claim, Jones Act claims are entitled to a wide array of recovery types: lost wages, loss of future earnings capacity, pain, suffering, and disfigurement, mental anguish, medical care, cost of living during recovery. In comparison, claims under general workers' compensation usually only cover basic medical care and a portion of an employer's lost earnings. This is not enough to help an injured seaman rebuild. What are my rights under the Jones Act? The Jones Act gives qualifying seamen the ability to file a maritime lawsuit after suffering an injury or developing an illness working on or aboard a vessel. Under the Jones Act, you can seek compensation for any injury that occurs as a result of the negligence of the vessel owner, operator, or another employee. This stems from the vessel's owner's duty to maintain a safe vessel. The same goes for any equipment on board the ship. In short, your rights as a seaman under the Jones Act include the right to a reasonably safe work environment, the right to file a maritime lawsuit if injured because of negligence, the right to maintenance and cure compensation related to injury or illness, the right to additional compensation if the vessel or crew is deemed unseaworthy, the right to additional punitive damages if refused payment of maintenance and cure. Can I file a Jones Act claim against the ship owner? Federal law recognizes the inherent danger of working at sea and risk of on-the-job injuries in the maritime industry. To keep a workforce of trained seamen, the law gives Maritime workers' valuable legal rights, including the right to sue a ship owner for negligence for unseaworthiness of the vessel. In a Jones Act claim, this act is more specific than common. Now we will be discussing more about it on next video. Till then, Allah Hafiz.